Tony, it's great to have you on. I'm really interested to kind of know what your attraction was to the law and how you found yourself in succession law.
In high school, I was always very interested in debating, analysing, and being able to express my views to hopefully make a difference. I suppose I chose the law because it played to my strengths and my interests insofar as the English language and analytical and critical thinking. And my passion for it grew when I got involved in university politics because I don't like to complain about something unless I'm willing to have a crack at changing it.
Sounds very vocal. Sounds like that's the common theme that I'm getting here.
Pretty much. Everything from a central sort of perspective has been about making change in other people's lives for a positive reason and in a positive way. So I got involved in the student politics because I went to James Cook Uni, which is regional and doesn't get as much funding and has far fewer facilities, lower socioeconomic student base, all of those sorts of things that make you want to help out. And I actually, when I graduated from the law, wanted to be a tax lawyer.
Wow, there's not many people that come out of law school thinking, I'm going to be a tax lawyer, like maybe big shot corporate or criminal lawyer. A tax lawyer, I think, is like probably at the very bottom of the list.
I found it very interesting, and now that I practice in succession, estates, trusts, and all of those more sort of fiduciary areas of law, I'm finding that the tax knowledge is very, very useful because it really helps plan with the client's ways alongside their accountant and financial planner. We can maximise what they can receive from the government and minimise what, after all of these years of working hard and paying taxes, they have to pay the government in retirement. So I didn't necessarily plan on becoming a succession lawyer, but I found after I'd practiced as a commercial solicitor and business solicitor for quite a few years, and I had a little dabble with family law and crime for a couple of years. None of that was really motivating me to go to work every day. And the firm I was working for was closing down because the principal was heading into retirement, and I took a job at the Public Trustee of Queensland. That was where I learned to love estates and trusts and succession because equity underpins it all.
So let's talk about it. So a lot of it is estate planning and then dealing with deceased estates. So before someone dies, in simple terms, and then after someone dies. Now, what do you think would be something that's interesting for somebody that's listening that they wouldn't know, or something that you find interesting consistently in this practice area? Because a lot of people will think about it and be like, hold on, we're just talking about planning for our death and dealing with things after death. Sounds pretty boring, sounds pretty morbid. I'm just imagining that's maybe a perception out there. So what would you say to dispel that perception?
You get a level of certainty and a lack of stress from knowing that you've put in place the appropriate documentation to provide for the people you've done all of that hard work for, and to make sure as much of it as possible ends up in the hands of the people and or charities or whoever your chosen beneficiaries are. Importantly, you should be having conversations about your estate planning and succession planning, I would say. But people with children and people who have spouses or blended families should be looking at their estate planning with a view to simplifying the process when they pass away and making sure that everybody who should be provided for is, minimising the risk of litigation around that. But most importantly, just having an executor appointed. A lot of people don't realise that in absence of a document, being a will, appointing an executor, there is nobody wearing a hat that gives them authorisation to deal with any of the deceased's assets. And that can cause a lot of delays. And depending on what assets they had when they passed away, it may be that you are required to get authority from the court to be the administrator of the estate in absence of a will, And that will usually take between 6 to 9 months, all things considered, with the processes involved, and will cost thousands of dollars extra. When you could have just done a simple will that appointed an executor and gave whatever you have worked hard for to your beneficiaries.
But on a daily basis, we're talking about people's death, something that I think a lot of people want to avoid thinking about. But for you, it's a daily encounter where you're either discussing it and putting the realization into people that they are going to die, or you're discussing a loved one's death or an estate or something like that. Does that have an effect on you in your personal life, or how do you kind of find that? Because I think a lot of people would think it's a bit of a morbid topic that they want to avoid. So how does that play with you, and does it have an impact on your personal life?
It does, but I would think in a positive way, and I'll explain that because, of course, I deal with people who are grieving, and everybody grieves differently. And as you're aware, I do a lot of litigation, both before and after people's parents have passed away. So what it's given me is a very strong sense of pragmatism in everyday life outside the office, and that there are so many people out there struggling with so many different things. It really helps to put into context those things that you in your own everyday life might otherwise cause you anxiety or worry or whatever it might be. So it helps keep things in perspective and to remember the positive things in life and the reason why you get up and do what you do every day, particularly for the family and, you know, close friend network.
So are there any interesting types of cases that you're seeing, or something that you're seeing on a regular basis that people should be aware of?
I see a lot of people being appointed as executors of an estate on the basis they're the ones doing the what I like to call heavy lifting of caring for mum or dad, you know, whichever one, usually one of them is left, and where there's a multiple amount of siblings involved, there'll usually be one who's really involved in the day-to-day care of that parent, which then makes them a logical choice to be the executor because they're often, already looking after the deceased for those few years prior to their passing, and the deceased has great trust in them. But then the will goes on to give the estate to grandchildren, for example. And the courts will always say that you have a moral obligation, which is a term we use carefully in this situation, but there is an expectation that you will provide for your children. And the greater the need of your children, the more the court is willing to intervene. The court doesn't like to rewrite a will, but they like to see, and rightly so, fairness play out. So to appoint, say, your daughter who's done all the caring for you and really done the caring that most people wouldn't have the stomach for, are appointed as executor and then share the estate. I've got one where she shares it equally with all the grandchildren. So she gets 1/10.
Executor being somebody that's appointed in the will, it's a special role, and that person is going to enact and follow the wishes of the person that's making the will, and it's their responsibility to see out the course of those wishes in the will once that person has been deceased. Have I captured everything there?
Yep, their primary duty is to call in the assets and give effect to the terms.
Yeah. And so I guess, do you think that sometimes they get forgotten about? Like, are people just not considering giving them something and they think they are giving them something by appointing them executor? Or do you think that's kind of intentional where they're like, well, you don't actually need anything, I want to cater for the next generation?
It could be any, and I've seen any one of the instances you've named. I've seen it done because that's the child the deceased trusted the most, or the one who is really good at books, or I've seen religious reasons for, particularly with some cultures perhaps, women receive less provision than others, and I say that with no criticism at all, but in Queensland, and as I understand throughout the other states, you can't provide less for somebody in a will because of a reason which goes against public policy. So gifts can't be conditional on marriage or adhering to a certain faith or things like that. So you end up needing to ask the court to give you more out of the estate because that really is what's fair.
So would you get instructions when you're sitting with a client, someone saying, I want to give my estate to, let's say, my son, but I'm worried that his wife's going to divorce him, and so I want to make it conditional on him, staying in a marriage for the next 10 years. Are there any kind of strange requests like that when people are giving instructions for a will?
Oh, it comes up a lot. General advice is always keep it simple. The more you restrict the executor in being able to exercise their discretion, because you can never predict what the lay of the land is going to be.
But what are some of those requests that you've heard?
Waiting till somebody's 35, which is, I think, in this day and age, perfectly logical. But the court will wind up monies held on trust for somebody over the age of 18 if that person over the age of 18 asks the court to do so. There's a lot of complexities that clients might ask about, but which I advise against because it's not going to achieve the outcome they want. You can never get around somebody's statutory right to make a claim against the estate or their ability to query whether the will was validly made, and therefore you really need to keep your estate planning to a minimum. You need to keep your estate planning as simple as possible so that your executor can do the job needed at the time.
Well, I think it's a question that will get asked a lot, and what you mentioned in terms of the kids, if there are kids, and you're distributing your estate to them, and that is, you would often see that in the family structure, one child would have more responsibility than the other, or there's one kind of child that's looking after the parents a lot more than the others. Maybe there's one child that's overseas, or maybe there's one child that's like living with them. And in those instances, is it warranted to then distribute the estate in a different kind of format as opposed to equal shares? Or do you feel like that's going to open up a can of worms and potentially a future claim from the child that obviously receives the least?
I'd actually agree with both statements. The testator's got a reasonable explanation as to why they might have divvied up those percentages, but ultimately the person whose will it is in charge of deciding where their stuff goes. My role is simply to give them an idea of all of the potential worst case scenarios so that they can make an informed decision, and I can record good notes that might be useful down the track should somebody say, hey, I should have got the same as my sister, even though I was overseas and I didn't do anything. And most of what I get is probably going to go in taxes anyway.
And the court, will they consider those reasons? Like, as in, I'm going to allocate more to this particular child because of these things. The court will be like, yeah, that makes sense. And the opposite, I'm not going to give as much to this child because I haven't spoken to her in the last 12 months. I see her once every 5 years. Are those adequate reasons that the court will look at?
Not really. They go to explaining the situation, but it really comes down to demonstrating a need for either adequate and or further provision from the estate. So your actual financial, along with the relationship you have with the deceased, in the context of the size of the estate, would probably be the key things to think about. So even if I was the one who did all the caring, if I'm in a far superior financial position to a sibling of mine who's one of the, as we colloquially refer to them in estate litigation, lame duck. Unfortunately, that lame duck may be able to prove a need for further provision than the supportive child who's better off financially. And that can be a really frustrating part of the practice in that area, because you've got to tell people things they don't want to hear and that you can understand would be frustrating, but it's the position the court's going to take.
So it's more of a we need to provide for those that are in need. That's like what the court will view, as opposed to, you know, this person didn't talk to the parents or didn't help out with the parents. They're just going to look at it that, you know, you brought this child into the world, you need to provide for them at some point.
Absolutely. And I did a lot of, I'd say about 90% of my case load when I was working with the government was applications for provision from an estate on behalf of a disabled child of the deceased, to the extent that they are reliant, prior to the monies in the estate becoming available, they're reliant on the government. And certainly when I first started in succession practice, reintegration into the community for institutionalised people was still a new thing, as horrible as it is to say. A lot of the work was done, and this was all pre-NDIS, so the funding was really not there at all. The litigation served a purpose because it would ensure that a parent had provided for their disabled child, as much as the brothers and sisters might not have liked that.
So if we're talking about a potential beneficiary that isn't going to receive an equal share in the estate, would you think the best approach is just to leave them out entirely, or would it be to allocate maybe a lesser portion to that beneficiary?
Again, I'd leave it up to the client, but my advice would be very much dependent on how their estate looks, so the nature and extent of their estate. I would want to get instructions on the respective financial positions of the proposed beneficiaries and any eligible parties who might claim on the estate, and make sure that the client's decision is an informed one, because it really makes no difference whether you give them $1 or $10,000. And I've heard this a lot, it just in general in the public. Oh, if I give him $5 or $1,000 or 10 grand, he can't claim. And that's just not a thing. It's a statutory right. You can't do anything about it. All you can do is make sure people know why, make sure your solicitor knows what your estate planning is.
So have you seen any horror stories when it comes to dealing with the preparation of a will, and something that has only come about once the person has passed away, and there's been a real calamity or disaster as a result of the estate planning in the first instance?
Absolutely. Probably the most prevalent would be people who die unexpectedly without a will at all, especially if they're younger, especially if they have children and they have a spouse, and perhaps the parents of the younger deceased person do not like the spouse. And it can become very challenging to administer one of those estates, because you're essentially got a parent who's lost a child far sooner than anyone would expect, a spouse who's lost a partner sooner than anyone could expect, and there are infant children involved. The absence of a will always creates an issue. It's just worse when there's a wife or husband or other spouse, anybody who's recognised as a spouse under the Act, and infant children. The rules of intestacy, so the default provisions, if you don't have a will, here's how your estate will be divvied up. There's no getting around that unless you can come to an agreement with everybody affected, is to provide a bit for the spouse and then to divvy up the rest between the spouse and the children, which would usually be a nonsensical outcome and not in accordance with most people's wishes.
Well, you say that the biggest issue is if there's no will, but I think the stats show that around half of all Australian adults don't have wills in place, which means that there's a disaster looming for 50% of the Australian population.
And as a litigator, all I can say is hindsight is always 20/20. I would think it would be more than that. who don't have a will, and in these days, just as, if not more importantly, a power of attorney, an enduring power of attorney, because your will only kicks in once you're no longer with us, and there could be, regardless of it being dementia or Alzheimer's, it could be that you have some sort of effect on your cognition such that you need help making decisions. And if you don't have a power of attorney in place, you might not have anything left to give under your will, because it might not end up with the right administrator taking care of your finances while you're still here. So both
Have you seen
both
that
those.
occur before?
Sorry?
Have you seen that occur before?
Yes, absolutely.
Yeah. So when you have somebody that's administering someone's finances, they might not be in the right state of mind or unconscious.
Recovering from a stroke, where there's impaired capacity for a while, but rehabilitation is, expected and happens. The war story I usually go to is the 35-year-old business owner. He was a tradie, so he did the usual, just ran a business through his ABN, had all of his QBCC staff, had, business bank accounts, everything was in his name. So not only was his wife coping with the concept that her husband had had a massive stroke at 35 and what are our lives going to look like going forward, there was a complete inability for her to deal with any of the finances or the assets. Right down to simple bank accounts, that he would pay the bills from those accounts, etc. He didn't have a power of attorney, and she had to make an application to the tribunal just to get authority to deal with her husband's assets. And he came good. I do like to point that part of the story out too, but that was nearly a year of a very difficult time for one woman and her family, but for the existence of an enduring power of attorney. Very simple document, and it would have made all of that run much more smoothly.
If you think about like the proportion of how simple a document is and how much of an impact it has, it really is just astronomical what these basic documents, wills, power of attorney, if they get done, you can just do them one time, and the impact that it can have at some stage of your life just being absolutely huge. Whereas, we do all sorts of things every single day of our lives to, just get the most minimal of impacts when it comes to our finances or to our futures or to our legacies. For some reason, the stats show 50% of Aussies, they haven't thought about it. They're thinking about other things. They're thinking about, their mortgage payments, or they're thinking about their rent, or they're thinking about having this, but it's all tiny when it comes to the impact of these other two documents.
Absolutely. And I think people probably don't appreciate the complexity of knowledge behind even a simple will, and that in drafting the simple will, an experienced solicitor is going to know which words mean what, because it was disputed in a court 150 years ago, and why we use specific terms and why we draft things a certain way, because we know all the legislation and the case law for the last couple of 100 years that tell us and inform us as experienced practitioners what needs to go in the document and what doesn't need to, because we know as litigators what the impact of even one or two words used incorrectly in a will can have.
Yeah.
Or if the will's not signed exactly the way the legislation requires.
A scary warning for everyone out there.
Don't lose your original will, ever. Leave it with your lawyer. Keep it safe. It's very expensive to administer on a copy of a will.
Yeah. Some good words of wisdom. Thank you, Toni. Well, it's been an absolute pleasure talking to you. A fountain of wealth, of knowledge that is coming out. And I think it's great to kind of see you delving into this practice and bringing a lot of light and joy to people where they think this is a real dark and serious time. I feel like that's really your strong suit. So Keep up the good work, and hope to chat again to you soon.
Yep. Well, as I tell a lot of my clients, or our clients, lawyers aren't good for much, but we are very good at paperwork, and if we can do a bit of that and take away some of your stress, then we will have achieved something for the day. And it's really the client satisfaction and the reassurance that we give people in the community that keeps me going every day.
I can see that and I appreciate it. Thank you, Tony. Catch you soon.
All right, not a problem.